Thank you to the Extractives Hub for hosting this webinar and for providing us with an opportunity to present on a topic that is dear to us, which is maritime delimitation and maritime boundary disputes. And I'm very pleased to have with me for this webinar somebody who is among the leading geoscientists in the field of maritime boundary delimitation. He is the creator of the most sophisticated software program called CARES LOTS, L-O-T-S, Law of the Sea. Robert van der Pol, Canadian. We will say a few things about our platform here at the University of Dundee, because I'm presenting from Scotland, and Rob is dialing in from Houston, and I will let him introduce himself in a few minutes. We hope to share with you our insights in this field. Again, it's our passion. We present all over the world. We have teamed up to provide perspectives from both the legal science, in my case, and geoscience, in Rob's case. And we would like to share insights with you from our backgrounds. In my case, I worked for several years for the International Court of Justice in The Hague, which has been the front runner for maritime delimitations through an adjudicated way. And I'm also teaching in this area in international law and law of the sea here at the University of Dundee. Rob, over to you.
Good day, everybody, and thank you for joining in on this webinar. Again, thank you to the Extractives Hub for arranging this. It's quite nice and interesting. I'm sitting in Houston, and as you all know, Peter is sitting in the UK. Pete has said most of the background. Of course, everything you're seeing that has a scientific component of law of the sea, I'll be handling, and Peter is handling all the legal side. And as most people know, law of the sea is equally legal and scientific. So it does take our two unique backgrounds to come together to do an interesting analysis. Today's slideshow, we're looking at analyzing the special chamber, how they fix the maritime boundary between Ghana and Cote d'Ivoire. So we're going to be going through that. There's a little bit of background that we will show initially as Peter and I were doing analysis leading up to the final ruling. So we have some interesting slides on that. Plus the ongoing issue of law of the sea is never resolved on this planet, as you will see, and we will actually touch also for Ghana on the eastern side with Togo. And we'll cover all these in the following slide deck, and then we'll take questions. So back to you, Pete.
So I think we can start the slideshow, Rob.
Okay, just let me give a little bit of a disclaimer here. I think everyone knows that these are sensitive things. This is international issues, so law of the sea. We've done everything possible. We always do tell people that these slides are somewhat controversial, so they're the best that we have it, but if there is any updated information that anyone has that's dialing in, please let us know, because this is an ongoing project. And also, as always, we'd like any of these figures sort of with our permission. So there is a couple of new things that will be covered in the slide deck at the end. Back to you, Pete.
All right, so let me just introduce the platform we have here, which is a knowledge hub of all things maritime boundary related. It's called Dolphin, and it stands for Dundee Ocean and Lake Frontiers Institute and Neutrals. Rob and I are the founding directors. We consider ourselves neutral. He's Canadian, I'm Dutch, and we look at it from the geoscience and legal science perspectives. We have a web page here at the University of Dundee, and it's displayed on the screen, sites.dundee.co.uk/dolphin, DOLFIN /, which has links to all the adjudicated boundaries that we are aware of, and quick links to all the various websites that are of relevance in this area, including the United Nations. And we invite you to visit that website and profit from all the knowledge that we have placed on there, including our outputs in terms of written reports, including a report on this ruling by the Special Chamber in 2017, as well as our latest articles and presentations from conferences that we will be referring to during this webinar. So we did a report for Dolphin especially, and we also did a report for the American Society of International Law Insight series that's publicly accessible, where you can read from A through Z what we have done in terms of analyzing this case between Ghana and Cote d'Ivoire. Rob?
Okay, just some background. Law of the Sea is a global marine mapping application. It impacts 162 countries the way that, at least on the scientific side, we at Fugro manage it, because we're handling all the great African lakes plus the Caspian. So we set the number at 162. There's about 169 million square kilometers of global waters in that slide, global EEZ waters. And of course, for today's exercise, we're focusing on the red area there, which is Ghana regional. So we're going to be looking at Ghana, Cote d'Ivoire, to the western side, and primarily the analysis that Pete just mentioned on the report that that he showed you the links to. But we're also going to be looking east Togo towards for that side for Ghana. So just to set the stage here quickly, what is the status of maritime boundaries around the world today? That is as of 2019, and again, this is a live database that we use. There's about 501 EEZ maritime boundaries, or boundaries inside the EEZ in the world. 250 of 501 of these are signed and or in force. That means 49% of the world is safe, and that means 50.1% of the world's offshore boundaries are unresolved and or in dispute. So on the bottom you'll see there that I say today 1 out of every 2 maritime frontier boundaries are disputed, and this is a perfect slide to show for Ghana, because we know the western frontier has been resolved through the Special Chamber and yet remains unresolved on the eastern side. Negotiations are going on, but it still remains at present time unresolved with Togo. So just a little bit of my background. I joined Fugro 14 years ago. I had written the software, Keras Lots, as Peter mentioned, for the United Nations. But there needed to be a database that was assembled. And when I joined Fugro 14 years ago, I started combing the halls of Fugro and the planet looking for data sets. So we now have 95 terabytes worth of digital data. We have completed over 1,800 projects for Law of the Sea specific in 142 of the 162 countries that we globally take on for Law of the Sea. And you'll see in that slide deck on the screen right now, we've divided the world into 6 regions: North America, South, Europe, Africa, Asia, and Oceania. You'll see the countries contained within, and then we have 2 polar stereographic data sets that cover the Arctic for Law of the Sea and the Antarctic for Law of the Sea. But the one shaded in red there is the African compilation, and all the data sets and everything you'll be seeing in our presentation today utilize data from the Fugro Global Law of the Sea database, specifically in the African region. So just some Law of the Sea background information. This is a preliminary review of Ghana, Cote d'Ivoire, unresolved disputed boundary. This next slide deck was presented by Peter and myself at Upstream Africa Conference in Cape Town, South Africa, in November 2016. So this was prior to the Special Chamber's decision and ruling. Pete, do you have any comments on this slide before I launch into the review of the past?
No, Rob, go ahead.
So this is just a preliminary assessment that we had done back in January 2015. It was active, but we're looking at the region. So this is slide deck is a picture is a 1 to 4.5 million scale. You'll see that step 1 in our steps, the relevant regional area of interest: Liberia, Cote d'Ivoire, Ghana, Togo, Benin, and Nigeria. Of course, we're needing to have Ghana, Cote d'Ivoire, and the maritime frontier in the center of the desktop study. We needed to do an initial analysis review of all baselines, even though some governments have the rights to use straight baselines. In this case, we were producing and we are looking at the blue lines, which are normal baselines, which every coastal state can have covering their coastal frontier. From those normal baselines, we produce the next, which is the Law of the Sea EEZ limit, the 200-mile legal limit line, which is the red line that you see offshore, that was computed from all the blue normal baselines for each of the respective countries. Step 4, the treaty boundaries. We actually only have one in this overall region, which is from Benin and Nigeria on the easternmost side of our study area. Every other frontier remains unresolved. Next, we need to look at regional suggested maritime boundaries. Now, these are 100% hypothetical, but they were computed using the standard court's procedure of strict equidistance lines calculations. You'll see Liberia, Cote d'Ivoire is a line. You'll see that Togo and Benin and Nigeria and Ghana have. But the main one is the black line on screen. This was Ghana's suggested maritime boundary. It was a unilateral suggested line. But this was the line that everyone used in the region, and this was the line that Ghana actually also submitted in the court case. Here was Cote d'Ivoire's line, completely different, unilateral again, so one state's opinion, and you'll see that it completely runs different to the line that Ghana had. So this defines basically our overlapping claims area, where the focal point of the reason for the court case was. And you can see it's about 31,146 square kilometers geodetic. Now, just some basic background. Ghana claimed the boundary line looked like this, and it was a customary line from the 60s. You see the line work there, the black dashed line more or less generally followed the immediate coastline, and it was a 90-degree or perpendicular line. And just to explain how, in the background, this was again from Pete and I doing some work in the area. This is how Cote d'Ivoire tried to claim the line with their logic, because they have a very concave coastline. You'll see the red area shaded shows the indentation, whereas the pronounced convex for Ghana, they ran a straight line through all the land terminus points for all the neighboring countries and then ran a perpendicular line. So they had still applied the same perpendicular line that Ghana did, except Ghana only used the immediate coastline, and Cote d'Ivoire applied the logic of all the neighbors' coastlines to do it as a large regional line. So this basically shows some things. One applied thing here in the slide, you'll see the red dashed lines if we were to apply Cote d'Ivoire's logic. The interesting thing was the lines on the east side, which we will do analysis on. But we're going to go through another slide deck in a moment, but this slide here shows the black area that we will do a detailed review on just for this specific court case. Pete?
All right, so the subtitle for our webinar presentation is the role and risks of concessionaires. Now, Maritime...
Just a minute. Okay. Rob?
Yes?
Is your volume okay that side? Because I see here. Okay.
I'm sorry, what's going on?
It's fine. Like, I think your volume was off, but it's okay now. You can continue, please.
All right, so maritime boundary cases often are triggered by competing claims to natural resources. And this case between Ghana and Cote d'Ivoire is a prime example. So problems arise when you have an oil field with one or more reservoirs, that is, a single pressure-connected accumulation of hydrocarbons that cross or straddle an international boundary which is in dispute, or otherwise has not been delimited by the claiming coastal states. So does the private sector have a role to play in maritime boundary disputes between two coastal states? Well, as a rule, this is the purview of sovereign states. So oil companies cannot be formal parties to boundary cases. But foreign companies can and should work with the disputing states. Now, the goal here is to be a help, not a hindrance. A help means providing geological or other data to both states if requested, or proposing useful constructive solutions for the boundary, or identifying experts such as Rob and myself in a neutral way. So states are the disputing parties. The companies, their concessionaires, have to be careful not to take sides. So hindrance means that foreign companies should take care not to take sides with one state or another. They should not engage in aggressive lobbying. They should not put undue pressure on states. So for instance, they shouldn't barrage governments with visits and phone calls. And I had a colleague who spent some time in the Prime Minister's office in a small, newly independent country, and she told me that oil companies would call her and call her office all the time, and it drove them crazy. Definitely they did not do their company's service. So this is sensitive. In the case of Ghana and Cote d'Ivoire, we would point out that there was an uptick in oil and gas activities in the so-called TEN field, T-E-N, offshore Ghana, which is in the area of overlapping claims. And rumor has it that the concessionaires were pushing Ghana to institute unilateral proceedings against its neighbor, Cote d'Ivoire, following a decade of negotiations on the boundary. I stand corrected, 6 years and 10 rounds of negotiations that failed to result in an agreed or treated boundary. And I cannot prove that the oil concessionaires in this case did anything to push the parties to an adjudicated solution, but these cases are very expensive. Just to point out, Ghana had 48 people on its team in the case, and the case lasted for 3 years. So you can imagine that's a multi-million-dollar proposition, and somebody needs to pay for that. Okay, next slide. All right, so if you have that stalemate, if you cannot resolve it through consultations, and the question is, well, how do you go about as a state? What are the what I call the policy options for disputing states? Now, in terms of policy options, coastal states with overlapping claims to maritime areas have a basic choice between finding a bilateral solution or seeking third-party assistance. And the United Nations Convention on the Law of the Sea, or UNCLOS, calls for negotiation in good faith of, quote, provisional arrangements of a practical nature, end quote, pending final delimitation of an exclusive economic zone or continental shelf. And examples are the creation of a joint development zone, or JDZ, where the disputing states agree to disagree on the boundary and they proceed to joint development of an overlapping claim area. And a prominent example is actually found next door between Nigeria and Sao Tome and Principe. An alternative is an international or cross-border unitization, but only in cases where a discovery has been made. And these provisional instruments enable the decoupling of questions of joint development from question of sovereignty or sovereign rights over maritime space. Now, the disputing states can also seek to delimit the disputed boundary through negotiation or through non-binding mediation or conciliation by a third party. Or the boundary dispute can be submitted to a third party adjudicated solution, either through ad hoc arbitration or adjudication by a standing tribunal. Now, self-help through the use of force is prohibited by the United Nations Charter. A state is permitted, however, to use self-defense, but only after an armed attack has occurred. We have seen instances of states shooting at seismic or drilling vessels in disputed areas. Next slide, please.
Okay, back to me. We're going to do a little bit of a detailed review here now. So you saw the regional review. This is specifically detailing the actual court case. Step one, Ghana's claim line, as I showed earlier. You'll see the black dashed line here. You'll see the relevant coastline here that the court chose for the analysis. You'll also see the backdrop, which is showing you the seabed and the continental shelf. Now, step two, Ghana actually submitted their Western Extended Continental Shelf claim here to the CLCS, the green area there. But you saw that the western side remained open because they were assuming that some type of a maritime boundary would define its extent. You'll see also at the time when we were doing this in January 2015, these were all the offshore issued oil and gas concession blocks, the PSCs, by the GNPC, Ghana National Petroleum Corp. Completely opposite, here is step four, Cote d'Ivoire's claimed maritime boundary line. Again, unilateral. You saw I showed how that was taken through all the land terminus points for the region to try and, remove the concavity of the coastline. Now, oddly, their extended continental shelf submission, they did just like Ghana. They submitted, it's all the way over to the west. So it does not track along their claimed unilateral boundary line they lodged in the court proceedings. All their blocks do follow. So here again from Drilling Info at the time in 2015 were all the blocks. We have all this information, and these were the blocks as issued by the NOC in Cote d'Ivoire. The blocks in question at the time with the overlapping claims area are all the ones in black. And Pete mentioned the 10 prospect. It was even starting to migrate towards the Jubilee. These are $2 and $5 billion discoveries, so there is a lot at stake. And offshore, I'm also in this slide showing you the extended continental shelf. So at the time in 2015, when Pete and I were analyzing this, we thought, okay, one of the possible rulings is the court could side 100% with Ghana's claimed unilateral line, and you would get that red dashed line, and that would be the result. Or, controversially, or 100% opposite, the court could side 100% with Cote d'Ivoire, which obviously would have been detrimental to all the blocks in the fields and the discoveries that was ongoing in the offshore for Ghana. Now, this is a line that we produced in our analysis. This is the by-the-book line, the one the courts always like to use, strict equidistance line methodology. And you will see in our calculations, it was shifting, the red line was shifting into Ghana. Now, to tie this back in, Pete and I have done quite a lot of research on all past court cases. You'll see here, the slide inset is from the Guyana-Suriname case of 07, but there's actually 5 court cases listed there that use that same methodology to support that line. One comment, the coastal area is very poorly mapped. I know I worked this region extensively. This is a high-res slide, 1 to 2,500 meter. You'll see the green star was Ghana's claimed land terminus point, and the red star is Cote d'Ivoire's. Here's some new stuff that we're using. I'll discuss this a little bit later on, but this is the new 4D SSN that we globally use for preliminary mapping. You can see offshore, the red line was the line in the coastline. You see that there's a lot of offshore features in the shoaling shallows that could be used for normal baselines. A complete opposite to the 2 previous lines the court could have chose is just this simplistic line running more or less due north-south, and they basically would split the 2 unilateral claimed lines down the middle. This was actually used in a court case, Nicaragua, Honduras in 2007, and they successfully applied it there. Now, would the court use it here? I guess we pretty much know the decision as we look further ahead, but this was one of the options to the chamber. Here's another one. It's a little bit of a modification. It's a relevant coastline bisector strict equidistance modified line. It does more or less still sit similarly to the strict equidistance line, and again, it shows that it cuts into Ghana. This was successfully used in these 5 court cases listed from Libya, Tunisia, starting in 85, all the way down through to Bangladesh, India in July 2014. And you'll see that there's coastal frontage and relevant coastal frontages that are being considered. Now, another one that many people don't normally think of, but the extended continental shelf is actually starting to factor in heavily in a lot of the analysis that Peter and I have done on all these court cases. So here are the two submitted then extended continental shelves. Looking most recently in Bangladesh, Myanmar, Nicaragua, Colombia, and Bangladesh, India in 2012, 2012, and 2014, the court looked at it. And that would mean that yellow conic area would be looked at. Now, to wrap it up on this slide, just to show you, even though Pete and I did this in 2015, the red dashed line you see now superimposed on top of this figure is actually the court's final ruling, the special chamber. Pete, did you have any comments on this slide deck before I move on?
So yes, the special chamber case is unique in that it was the first maritime boundary case in which one of the parties, namely Ghana, had already received and accepted recommendations on the outer limits of its continental shelf from the Commission on the Limits of the Continental Shelf, a body that sits in New York. Well,
okay, Pete.
All right, so just by way of background, how did we get to this case? A state party to the UN Convention on the Law of the Sea may designate one of three compulsory procedures for settling a maritime boundary dispute. First, the International Tribunal for the Law of the Sea, or ITLAWS, which was set up in Hamburg, Germany, under UNCLOS. It consists of 21 judges, and it may operate as a special chamber of 5 judges, as happened in the case between Ghana and Cote d'Ivoire. Second, the International Court of Justice, which is the principal judicial organ of the United Nations, which sits in The Hague. It has 15 judges, and it's currently seized of a maritime boundary dispute between Somalia and Kenya, filed in 2014. Now, third, where designations by states do not match, or in a situation where no declaration has been filed, the default is to an ad hoc arbitral tribunal constituted in accordance with Annex 7 of UNCLOS. And in 2014, Ghana used this mechanism to sue Cote d'Ivoire, and the two parties then mutually agreed to transfer their case to a special chamber of ITLAWS in Hamburg in 2015. Now that opened certain risks for the concessionaires affected by this submission to a third party. Because what happened is that Cote d'Ivoire struck back and said, okay, you sue me, I will agree to the transfer, but I'm going to push for a moratorium on oil and gas activity offshore, pending final adjudication of our boundary. And the 5-member tribunal actually agreed, albeit not full 100%, but it did impose a 3-year, or actually for the duration of the case, moratorium on all new drilling offshore. So you can imagine if you're an oil concessionaire active offshore in the disputed area, then you're bound by this ruling, this injunction received by the two disputing coastal states. And that ruling on that prohibited new drilling in the area was in place for the full 33 months that it took the special chamber to adjudicate the case. Now, a body of maritime delimitation case law, or jurisprudence, has developed through some 25 decisions rendered by various international courts and tribunals since 1969. And through a technique Rob and I call reverse engineering, and relying on our legal and scientific expertise, we can apply the lessons from the case law to a given dispute and make informed predictions regarding its outcome. And you would hope that Ghana and Cote d'Ivoire did the same before submitting to this proceeding. And they could have learned that strict equidistance has been applied by international courts and tribunals, so that would plead in favor of Ghana in terms of the gamble it took. But no court or tribunal has ever sided with one party that advanced this argument of strict equidistance. Always been different. Lo and behold, in this case also, the strict equidistance line that was imposed on Ghana and Cote d'Ivoire was not in accordance with the lines advanced by the parties. Now, the ICJ in The Hague is the undisputed frontrunner with a dozen or so judgments, and you can find them on the Dolphin webpage. But it's slow. ICJ boundary cases take, on average, 5 years and 9 months to conclude. So you can imagine being a concessionaire and facing 69 months of proceedings for the adjudication of the boundary. ITLOS in Hamburg has adjudicated only one boundary case, namely between Bangladesh and Myanmar in 2012, but it did so in a record 27 months. And the special chamber of ITLOS in the case between Ghana and Cote d'Ivoire took 33 months. But again, that included a moratorium on new drilling for those 3 months. There have also been ad hoc cases that have been a little bit quicker, but over a 40-year period, this new case law, this case law has emerged from which we can extrapolate the principles that one would expect a tribunal to apply in a given case. Next. So then the question is, once you're in the court or tribunal, how does an international court arrive at an adjudicated maritime boundary? What is the delimitation process? Certainty, equity, and stability are integral parts of this process. And these elements are reflected in a 3-stage methodology developed by the case law. It's not written down in any treaty. This is the case law. The court will start by determining what is called the relevant area, and it does so by identifying the geographical context of the delimitation, including relevant coasts, protrusions, and offshore features such as islands. Then the court will establish a provisional line, typically, but not always, by drawing an equidistance line between adjacent coasts or a median line between opposite coasts. And at the next second stage, which is the most important one, the court will consider whether there are factors calling for the adjustment or shifting of the provisional line in order to achieve an equitable solution. So that is the final result that must be achieved, an equitable result. These factors that courts will consider are called relevant circumstances, and the case law favors factors of a geographical nature, such as a significant disparity in coastal length, over area-specific factors such as oil concessions and oil wells. And this is of relevance to this case because Ghana advanced a modified equidistance line in order to take account of oil and gas practice over several decades in the disputed area. Finally, and at a third stage, the court will verify that the unadjusted or adjusted provisional line does not, as it stands, lead to an inequitable result by reason of any marked disproportion between the ratio of the respective coastal lengths of the two states and the ratio between the relevant maritime areas of each state by reference to the delimitation line. So this is called the disproportionality test, and its application could result in an offshore island being given only half effect or no effect at all in the delimitation. That didn't really play out in this case. There were no marine offshore features that upset the line. So the court, as we will demonstrate, opted for an unadjusted or strict equidistance line, properly so called. Next.
Okay, just to loop out to the extended continental shelf for the area as well. This is the Gulf of Guinea, and this just goes to show you that law of the sea issues do not only take place inside the EEZ waters from your coastline 0 to 200. This is actually a slide deck showing all the claimant states in the region submitting their extended continental shelf. You've already heard me mention it earlier on. The red little polygon on the western side is Ghana's western claim. They had one on the east as well. Again, this was done back in January 2015, so this slide deck is old, but it's kind of interesting. It showed back at that time Togo had lodged a claim of over 10,000 square kilometers, beginning beyond the 200-mile. Benin had over 10,000 square kilometers. Nigeria had about 8,200. Cameroon put in a lodged claim, quite monumentally large, 159, and Sao Tome and Principe put in 37,000 square K. But the interesting takeaway for a dispute that is, bound to play out is the overlap of all 6 of those coastal states as lodged, submitted, and put their claims into the United Nations for the extended continental shelf in this region is almost 21,000 square kilometers of overlap. So if you think there was a problem for just Ghana, Cote d'Ivoire for a maritime boundary, try take 6 coastal states. Pete, any comments on this slide?
No, please move ahead. We only have about 10 minutes left.
I know. So here we're moving ahead. So now we're going to this next slide deck is just a quick review of Ghana, Cote d'Ivoire's maritime boundary ruling by the special chamber. Now again, Pete has already mentioned, and in our opening slide deck you saw the paper. We're welcoming you all to download it from our Dolphin website or go to the other website we set for the published paper, because this is quite a large document. We don't have time to cover every line detail. So this next slide deck is basically an overview of the figures that we used when we were reviewing the special chamber ruling on the boundary line. This is the final ruling. Pete, any comments first on this?
No, I'll let you speak to it.
Okay, so this is the final ruling. I think most people have seen this now. The interesting takeaways that what was very clear to us right away is that on this slide you'll see a BP 55 stands for base point or border boundary pillar number 55, but it's 55 plus. So the special chamber actually did not agree with the agreed upon one for eventually both Cote d'Ivoire and Ghana, and they moved it. Now, in moving this sets up a whole dynamic that most people never considered here, because by the special chamber essentially starting at a brand new land terminus point on the coastal land-sea interface, by definition under law of the sea, at the low water line, they have essentially meant that neither line, whether it be Cote d'Ivoire's or Ghana's, will be exactly the same based on this. You then see there's a list of points A, B, C, D, E, F, and then an azimuth out and drawn beyond the 200-mile. And they actually only used an extreme tiny piece of coastal frontage, and they list in this slide the base points that were utilized. So the blue ones listed on the bottom are Cote d'Ivoire, the green are Ghana. Pete, anything before I go on?
So this is probably part of those sort of risk assessment up front, where probably both countries thought, hey, we have bilaterally agreed on border pillar 55, so we know what the starting point is of our maritime boundary. Well, not so, because once the tribunal said no, we will apply the equidistance methodology for determining the preliminary line. Well, then we have to look at the low water line, and your agreed border post 55 is not on the low water line. So out the door go their advanced unilateral claims. Rob?
Okay, so this is just the first figure in our paper, the nearshore impact of the special chamber's choice of the maritime boundary, the starting point. So here's the slide deck. This was our review. So you'll see up in here, you'll see Ghana, Cote d'Ivoire. This is the land boundary agreed upon. Here is Ghana and Cote d'Ivoire's boundary pillar 55, but it's on the mean high water mark. You see it's even in behind my coastline in this slide. This is Cote d'Ivoire, this is Ghana. This figure is 1 to 2,500 scale. And at the time, the orange line was Ghana's final claimed line, the orange line, and the blue line was Cote d'Ivoire's final claimed line. The special chamber actually rejected that, moved it to what they called the low water line, which is actually a disparity, and it's a difference from 59 meters south and actually 18.43 meters east of boundary pillar 55, border point 55. So they started the boundary here, and then there's the line that is the special chamber line. Now you can imagine by doing a down coast and offset is going to be causing some problems. In this next figure, on a segment by segment difference analysis between the boundary and the claim lines, we basically do a detailed analysis. There's area A, segment A, B, and then C. You can see that how we're doing the analysis. And again, we are mapping this at quarter-meter resolution, how we do all our global work. So it's not that we're doing round-offs here. We do things, we split hairs down to the quarter-meter because meters means millions in the oil and gas sector for defining these boundaries. But you'll see that there's some offsets here, and it's all explained nicely in our paper. As I move to the next figure, this is the interesting part of the analysis. This is basically the starting point and then analyzing each of turning point A, B, C, D, E, F, and then the final azimuth termination. And you'll see actually the difference from Ghana's claimed line and the difference from Cote d'Ivoire's claimed line. And it's some are west and some are east, and you'll see that it crisscrosses, and it actually gets quite interesting because there's offsets in the 400 to 500 meter range. In other words, the final drawn Chambers line is almost a half a kilometer moved towards, in some locations, right through the heart of where the prize prime hydrocarbon of the 10 field is. So it's actually, there is some potential impacts here. So it was something that needed some consideration. Pete, any comments?
Yeah, so we believe that these figures that we've produced are the only one certainly available on the internet where we really show the impact in figures on the boundary and therefore on blocks in the area of overlapping claims. And the numbers just bring out the victory achieved by Ghana. As a matter of fact, except for the nearshore area, which is relatively short, it's just 30 nautical miles, but for the rest, almost 200 nautical miles, the line clearly is in favor of Ghana. And one could say that Ghana received a boundary that is even more favorable than it claimed before the tribunal. So that's quite remarkable. Rob?
Okay, this is just the analysis of the blocks at the time and what was going to be impacted. You could see that on this slide over here, some of the Cote d'Ivoire blocks are going to be impacted and which blocks were being impacted on the Ghana side. So it's all explained again in the paper in great detail, but it does go to show that neither coastal state went unharmed when it comes to the hydrocarbon industry. Both coastal states needed to make some modifications and or relinquishments to some portions of the blocks in question. Now,
Rob.
Sorry, Pete, go.
Yes, so just to point out that this ruling is final and binding on the two states and therefore also on their concessionaires. So the coastal states have to make these adjustments to these blocks. Pretty much all blocks before the ruling were affected by the ruling, and they will have to be adjusted. But I think it's fair to say that the main concessionaire of Ghana, Total, probably was very happy with the outcome. Now, we were going to cover the Ghana-Togo situation and do a simulation of, if you apply the ruling between Ghana and Cote d'Ivoire, what would that mean for the unresolved boundary between Ghana and Togo? But I'm afraid we have run out of time, and we will need to open up the questions from the floor, which we will be happy to address. Rob?
I'm going to just very quickly slide through a couple of these, Peter, if you're okay with that. It's probably 2 minutes.
Yes, 2 minutes is fine.
Okay, I just need 2 minutes for this. So we'll do this quick. So I'd love to do this longer, but we're going to have a quick initial review of Ghana-Togo. Okay, this is basically the area that we're looking at. First and foremost, it's all about mapping. You can see we have high-res imagery here from July. We've mapped the high water mark, the coastline, and we've located the little green happy face as the land terminus point. I had mentioned earlier you need to locate all the land termini. There's a whole bunch of analysis that we have done here showing the 40 SSM, trying to define where the normal baselines are, which are the blue lines that you see on screen. Moving on forward, we define for the study area the 200-mile limit, which is the red line on the east side. Moving even further, faster through this, we are defining existing treaties. There's the maritime boundary, Benin, Nigeria, August 4th, 2006, and the JDZ line, which is showing up in here, Nigeria, Sao Tome, and Principe. More importantly, we need to do some analysis on the maritime boundaries. Very quickly, here is Benin, Togo. This is a line that needs to be considered. This is the strict equidistance line by the book, showing in there. And then as we move ahead, the first obvious step for Ghana, Togo would be doing a strict equidistance line. You can see there's a massive disadvantage here for Togo if you just run this mathematically. Pete may make comments on this after, but you see that they would pinch offshore and impact with the Benin line. Applying the court line, and this is the main takeaway on this next slide deck, this slide that I'm showing. This has been applied here. This yellow line is the exact same logic that the court did apply on the western boundary between Cote d'Ivoire, Ghana, just using a very small coastal frontage and applying the strict equidistance line. So at least this line shows that Togo would get a limit. For the extended continental shelf, there is a recent submission, September 2018. It's about 5,090 square kilometers, that red area. And that black dashed line is showing what obviously Togo would have in their sights or their wishes if they basically have this ECS tied to their maritime boundary. If you go and throw everything together, you see the red line was the strict equidistance. The green line is the strict equidistance between Benin and Togo. The yellow line is Ghana, Togo by the court line. And of course, it's still completely not close to what Togo might wish. If you bring in the oil and gas blocks, the red ones are the existing offshore from Benin. The two yellow is the existing offshore from Togo. The two blue is the existing offshore blocks from Ghana. Interestingly enough, my yellow line exactly matches the block for Ghana. Interesting also, the black dash line that Togo would wish for, as coincides with their issued blocks, carves through part of this block. And again, all of this is matching nicely with our very quick initial analysis. But here is sort of the takeaway and why I wanted to close this off. And I apologize for really ripping through this quick, but we went a bit long. Initially, you'll see there's a 10% overlap right now. That is the contested issue between the two neighbors. This was here from January 1st, 2018, a fresh border dispute between Ghana and Togo. This is a press release when Togo intercepted two seismic vessels and halted them from working on this particular block because they claimed there was a disputed boundary. That set in motion some negotiations. This was a failure here after the third round of negotiations from December 12th, 2018, 1 year ago today. And when I looked even further, I found one from May 3rd saying still no progress in the Ghana-Togo maritime border conflict. And that, I'm sorry to say, was a little quicker than I wanted to do that on, but I guess we are now at question period. Pete, any other comments to throw in on that?
No, thank you, Rob. And that just goes to show that the same scenario as we saw between Ghana and Cote d'Ivoire might play out between Ghana and its other neighbor, Togo. And one would hope that they will have learned their lessons from the Ghana-Cote d'Ivoire ruling and try to resolve the question, preferably by negotiating a treaty. If not, agree to disagree and consider a joint development zone in the disputed waters between Ghana and Togo. But you would apply the same principles that we've laid out in this webinar, so you can make your own informed predictions. Questions?
Any questions from the room? Or any questions from our viewers online? Yes, Daniel.
So, Professor, thank you. Is there a figure? I mean, how many US dollars are we talking about in terms of Ghana's win here, in very round terms?
Well, we know what the prospect for the 10th field was. It was several billion. I don't have the number handy, but I think it was 2 or 3 billion. But that was, in 2015. then they couldn't perform any new drilling. So I think the number has been updated since the ruling, which was handed down on the 23rd of September 2017. So, looking at the ruling, looking at the prospects, we're definitely looking at upwards of $3-4 billion.
So we can see online. So if someone asks a question, you repeat for people to hear.
Okay.
Yeah. Okay. Any questions from the room? Yes, David.
Thank you very much. My question would be in respect of two different countries. I know that Nigeria and Cameroon in the past had experienced similar issues. So I wouldn't know what your comments would be if you would apply the tribunal's decision to Nigeria and Cameroon. Do you think there would be any significant changes to the maritime relationship between Nigeria and Cameroon?
So Cameroon v. Nigeria was adjudicated by the International Court of Justice. Actually, it's a case that was filed when I was working for the International Court, so I know a little bit about it. That took more than 10 years to be resolved. So the concessionaires, were uncertain about their concessions for 10 years. But in that case, the maritime boundary also was a strict equidistance boundary. So I would say Ghana and Cote d'Ivoire could have known that, given the result and the methodology applied in the Cameroon v. Nigeria case, they might expect something similar. I don't think there would be market differences if one were to apply the Ghana-Cote d'Ivoire ruling to the Cameroon v. Nigeria ruling. It has some quirks in that people have accused the ICJ of not being accurate in its fixing of turning points on that boundary. And this goes to show that the use of the most sophisticated boundary software, and we believe that is Kara's lots, is very important in these matters, not only for the coastal states, but also for the concessionaires, so as to quiz, are these coordinates for the blocks that we're receiving against payment, are they accurate? And the Ghana-Cote d'Ivoire case also underscored the use of Kara's lots by both parties. And the weak point from our perspective in the ruling by the Special Chamber in Ghana-Cote d'Ivoire is the reliance on a map by the British Admiralty from the 19th century, then digitalizing that map and then reducing base points, because when you do digitizing, you end up with a great many points. That is a bit contrived, and as we saw, the chart that was used was based on surveying done between like 1837 and 1860 or so. Highly inaccurate. So if that's the basis for measuring a boundary line, we believe there are better ways of going about fixing a disputed line. Rob?
Yeah, just a comment. When we looked at that, we were a little bit shocked that the Special Chamber had rolled it all the way back into using that old map. But one comment, both governments had used that map long ago. So I guess it really depends on the approach. But the normal methodology from all the 28 court cases that Pete and I have reversed engineered that made decisions, most of them, probably 95% of them, did actually request or required updated coastal mapping, because it's the geometry of the coastlines that define the baselines that then define the way the maritime boundary will be applied, at least for the strict equidistance line. And then if there needs to be shifting, as Pete has already mentioned, they will do some additional shifting to make it an equitable result. But if you go back to the best recent court case that we both understand, it was the Guyana-Suriname, and in that circumstance, both the government of Guyana and the government of Suriname brought in external assistance because they're both colonial former countries. So the Dutch fleet and the British fleet came in and they blanket mapped the whole coastal frontier. And that took quite a lot and millions of dollars that was donated by the primary countries, so in that case Holland and the UK. But when that data, and when they actually had it to modern day mapping precisions at that time, was the best that they could do, it moved base points almost 4 kilometers offshore from the old archaic hand-drawn maps from the 18 and 1900s. So that court case pretty clearly set the bar to say new mapping is golden, old mapping is not worth it. And in that case, they made a 100% strict equidistance line. And the interesting thing was that when Pete and I had looked at that before it went to the court case, our answers from our analysis was 97% the same to what $30 million in and 5 years in legal fees took about for the court to decide. We already had the answer. So it just goes to show you that when we do these desktop studies, coastal states do have the tools available to them if they just follow the logical procedure of what law of the sea should be. So that's just a bit of my input, but I got to say, when we did the analysis on the Ghana Cote d'Ivoire, we both were scratching our heads that the final rulings were made on maps that were based on 100-year-old mapping. So, but that is their right, and that's the way the outcome came. But for all the other ones we've ever looked at, detailed mapping is sort of the key here, and that's how we approached it. And I did that little desktop study that I kind of burned through a little too quick on the Ghana Togo. So just keep that in mind. That is at least the scientific takeaway from law of the sea that is key, in my opinion.
Thank you, Rob. We have a question online. I'll read it. In early 2015, why did the Special Tribunal reject the argument from Ivory Coast that all oil production should be seized while the matter was decided, so pending the adjudication? Well, the Special Tribunal unanimously agreed with Cote d'Ivoire that there should be a moratorium, but only on new drilling. So the Special Tribunal considered that an order suspending all exploration or exploitation activities conducted by or on behalf of Ghana in the disputed area, including activities in respect of which drilling had already taken place, would cause prejudice to the rights claimed by Ghana and would also create an undue burden on Ghana. And it also considered that an order could cause harm to the marine environment, presumably resulting from having to shut down ongoing oil and gas drilling activities. So that's why the special chamber modified the request, if you will. It can do that, but it still imposed a moratorium on all new drilling pending final delimitation through adjudication by the tribunal.
Any questions from in-house, yes, please?
Yeah, okay. Thank you very much, Professor. I'm from Cote d'Ivoire, and of course interested with that cases, which was a shock in the country. We know that when there is no maritime boundaries, the country has the choice to decide GTZ. And in that case, my question is, what will happen, or what will be the right of the concessionaire if the countries, both countries will decide about a GTZ, and both concessionaires invest in the drilling and so on, and after times the decision appear that Cote d'Ivoire has no rights in the fields. What will be the situation?
So that's complicated now because you have a boundary that's final, binding, and it's imposed on both parties, right?
Yeah.
So Ghana has the sovereign rights to the east of the adjudicated boundary line, right?
Yeah.
So it is under no obligation now to invite its neighbor, Cote d'Ivoire, to enter into a joint development zone.
Yeah.
And the joint development zone is basically about saying, okay, we recognize that for now, nobody has any sovereign rights. So let's go at it together, better together. We join and we share in the costs, but also in the benefits. Again, Ghana has no incentive to do that. As a matter of fact, Ghana has no duty to do that. What was painful, in my view, in the case is that Cote d'Ivoire actually said to the special chamber, wait, Ghana has never even negotiated in good faith such a joint development zone. And then the special tribunal pointed out, but you never asked them for one. So I think the prospect of a JDZ in this area, however efficient it could be from a cost sharing and benefit sharing point of view, are very, very, very limited.
Yeah,
Okay.
my
Hey,
question,
Pete, can I jump in for a comment?
Yeah, very, very
Yes.
quickly, please.
I just want to jump in just to further on to that. As Pete has said, obviously the boundary is final and binding on your east coast of Cote d'Ivoire, but have a look, as you heard me say initially, 1 out of every 2 boundaries is unresolved, and 100% unresolved is your boundary on your western frontier with Liberia. We are working quite heavily with both countries, obviously. I suppose to answer your question, it would be interesting to go and see what a JDZ might look like on your western frontier, because that's a new area opening. There's bid rounds coming, future bid rounds pending, and I happen to know personally that the unilateral lines by the two governments are drawn absolutely identically as bad with an overlapping claims area on your western frontier as was the lead up to the court case on the eastern frontier. So maybe lessons learned, but it's a bit of foreshadowing. That may actually play out on your western boundary as one of many, many options that you have in front of you. Pete, any comments on that?
Yeah, I think the JDC would make a lot of sense between Ghana and Togo. Interestingly, it was Benin who wrote to the special tribunal saying, wait, we're there, keep us in mind. And the tribunal pointed out, well, our ruling is of no consequence to the neighbors, so it's just binding on Ghana and Cote d'Ivoire. But international courts and tribunals have taken into account the limitations in the area, except that this is an area where we have a lot of undelimited boundaries. And I would point out that 70% of all of Africa's blue frontiers are unresolved. So these cases are important for future cases. And I think coastal states should heed the warning and try to agree to disagree with their neighbors and put in place a joint development zone while agreeing to disagree. And I think Cote d'Ivoire probably regrets not having pushed harder for that leading up to this case. And it's fair to say that Ghana took advantage of that with great success.
Okay, if there are not any questions, then we shall have to close. Any questions in-house? And we don't seem to have questions online. Maybe you can make your concluding remarks and share your contact details, which are already there for people to contact you if they have any other questions. But the video is recorded, so it will be available on our YouTube channel, on our website, so you can always check out the videos. I'll let Robert and Peter to make their concluding remarks, and that will be the end of our webinar.
Rob?
Yeah, so I'd really like to thank everybody for taking the time to join in. Slight apologies, when we do these type of presentations, unless the whole thing is a movie scripted and the slides auto-advance, we ran a little bit long. I would have liked more time to have gone through the analysis on Togo, Ghana, because we do have a nice slide deck, but it is in the presentation so you can see the results and hear the results. But again, thank everyone for joining in. I'd like to thank the organizers as well. This was sort of interesting, and modern technology, me sitting in Houston, Pete sitting in the UK, and many of you dialing in from wide and far. But again, you have our on-screen, you know how to reach us, and if you have any questions on follow-on that we didn't get to address in the presentation, by all means, please give us a shout, and we'll be more than happy to address your information. So thank you from me, Pete.
Thank you, Rob, and that leads me to thank you, my co-presenter. Very proud to be teamed up with such a learned and specialist individual on how to plot maritime boundaries, and to invite you to our webpage, Dolphin, again, where you can read our full analysis about this case and several other cases, including on the African continent. So thank you very much. Bye-bye.